Can you talk about how assets are divided during a divorce?
Yes. Anything that has been acquired from the date of marriage through the date that somebody goes to their local county courthouse and files a divorce complaint is subject to what we call equitable distribution. In New Jersey, we do not go by a strict 50-50 division. It doesn't matter if it's in one spouse's name or the other spouse's name, so long as it was acquired following the marriage, but before the divorce complaint was filed, a court can go in and make an equitable distribution finding and divide those assets and liabilities. The statute sets forth a number of factors that the court needs to consider. And a court could come down at 50-50 as to how to divide bank accounts, proceeds from the sale of a marital home, any other asset, as well as debts, split the debt 50-50. But that is not the law. It is an equitable or fair distribution. Now, a judge will likely start at 50-50 and look to see whether there's a reason to come off of that. But it's equitable distribution, not necessarily equal distribution.
And that's determined by the judge. The judge says this is 50-50 or this is 60-40.
Exactly. The judge is going to look at the factors that are set forth in the statute and find out what is fair. And if you line up 100 different judges, they may all find something to be a little bit different. So that is why it's important to have an experienced attorney to let you know what the possible ranges of outcomes are.
Is there something a spouse can do to be sure that distribution is fair and equitable?
The first thing we do in divorce cases is we file what's called a case information statement that is required to be submitted in all cases. And that asks for background information, income information, some budgetary information, as well as a list of all assets and liabilities. Once that's filed and we have all of the assets and liabilities listed by both parties, we'll generally exchange documents to substantiate the values of both the debt and the assets. After that, we will then submit what's called discovery, either written discovery or depositions, subpoenas. There's many different mechanisms under the law for us to obtain documentation. And with that, once we have an idea of all of the assets that are in the pot, in the marital estate, then we can begin discussing what's a fair and equitable resolution as to dividing the assets. It's very important for my clients, if they believe that some of their accounts or assets may be premarital, I will want them to get me statements, whether it's from a 401k provider or a bank, showing what was in an account prior to the date of marriage so that that is protected, because equitable distribution only relates to that of which was acquired during the marriage.
And what if I think the other spouse isn't revealing everything?
If one party is suspicious that there hasn't been a full disclosure, it's important for the parties to engage in the written discovery process. First, we would exchange written questions and answers under oath, which are called interrogatories. We would also send a request for document production. If there's still some concerns that not everything's been disclosed, a lot of times we'll have depositions, which is a question and answer session with a court reporter transcribing everything that's taken down, and that will be converted into a transcript form. Then you still have the ability to send subpoenas to different entities if you don't think that everything's been disclosed at that point. So there's many mechanisms through written discovery, depositions, and subpoenas to really try to uncover everything that's at issue in a case. And to the extent it's discovered that some things haven't been turned over, there's a real risk for the party that's not disclosing things that they could be hit with sanctions or attorney's fees by a court if the court finds they're acting in bad faith or intentionally hiding assets.
This is really helpful info, Brian. Thank you so much.
Thank you.